Welcome to this educational video designed by attorneys for plaintiffs who are contemplating bringing a lawsuit for non-therapeutic circumcision imposed upon them or upon their child. Today, our goal is to familiarize potential plaintiffs with what they need to know before bringing such litigation and to familiarize them with important considerations surrounding non-therapeutic, non-consensual circumcision of children. Hello. I'm Tim Hammond, Executive Director of the Genital Autonomy Legal Defense and Education Fund, or GALDEF. GALDEF's vision is a world in which the right of everyone to bodily integrity and the freedom to choose what's done to their genitals is legally protected on an equal basis. Our mission is threefold: to educate and assist attorneys with relevant resources and materials, to establish a nationwide cooperating attorneys network, and to raise the funds necessary to assist plaintiffs and their attorneys to bring successful impact litigation to expand the legal landscape in the U.S. to protect children's bodily integrity regardless of sex. Let's begin by defining the term genital autonomy. What exactly does that mean? According to one legal scholar, genital autonomy is the unified principle that children, female, male, and intersex, should be protected from genital cutting that is not medically necessary. In other words, children born with healthy, gender-typical genitals and those born with non-life-threatening, gender-atypical genitals should not be subjected to socially demanded genital cutting customs. Instead, they should be allowed to decide for themselves how much of their genitals they get to keep. What exactly is impact litigation? Impact litigation, or strategic litigation, is the practice of filing lawsuits to achieve systemic and lasting social or policy change beyond the specific case at hand. Instead of resolving a single instance of wrongdoing for an individual, these cases are designed to challenge flawed laws or policies affecting a broader group of people or society as a whole. These cases can be individual claims with broad significance or class action lawsuits, and often involve constitutional claims to drive change. Examples include women's reproductive freedom, civil rights cases, and marriage equality cases. Please be advised that some portions of this video contain graphic images of intact genital anatomy as well as physical harms inflicted by circumcision. In humans, both males and females have a foreskin that protects the sensitive head of the penis or clitoris. In utero, the male and female genitals develop from the same genital tubercle and are indistinguishable by sex up to about the 9th week of gestation. Even after sex differentiation occurs, male and female genitals retain their analogous structures. The penile foreskin is significantly larger than its clitoral counterpart. It's a dynamic, double-layered sheath of tissue that comprises up to 1/2 of the penile shaft skin and ensures optimal protection, pleasure, and sexual performance. In the adult, the double-layered foreskin constitutes around 15 square inches of erogenous tissue, or about the size of a 3x5 index card. Research confirms that the amount of tissue loss is more than most parents envisage. A landmark study of penile sensation determined that the foreskin is the most densely nerve-laden part of the penis, more so than the glans or penile head. Intact males reported that the greatest sensitivity is in the ridged bands of the inner foreskin and the frenulum, both of which are usually destroyed during infant circumcision. That study confirmed circumcision ablates the most sensitive parts of the penis. Circumcision also involves the loss of immunological protection. The inner lining of the foreskin is mucosal, which not only provides and preserves valuable lubrication during sexual activity, but, as with other mucosal surfaces of the body, like the vagina, mouth, nose, and eyelids, mucosal tissues act as the body's first line of defense against infection. At birth, the penile foreskin is adhered to the head of the penis and is not retractable until the two structures naturally separate as the child matures, sometimes not until after puberty. The American Academy of Pediatrics and other world pediatric associations advise against forced foreskin retraction in children, which can inflict trauma, damage the penis, cause bleeding, infection, and scarring, and can possibly lead to future circumcision. Forced retraction is not needed for hygiene and would be analogous to breaking a young girl's hymen in an attempt to clean inside the vagina. A good rule of thumb is only clean what is seen. Contrary to popular belief, circumcision did not begin in the Jewish community. It's a pre-Judaic rite that was first recorded among ancient Egyptians. Throughout early human history and across cultures, genital mutilation and sacrificial blood rituals were commonly performed to appease tribal deities and were often imposed on vulnerable children. During the First Temple period in Judea, priests adapted the local custom and made it mandatory for all Israelite boys on the 8th day of life as a sign of their covenant with God. Although still observed by many Jews today, increasing numbers of families in Israel, the U.S., and around the world are opting out of circumcision, many choosing instead a non-cutting ritual for both boys and girls known as Brit Shalom. The U.S. and the English-speaking world did not practice circumcision until the Victorian era of the mid-1800s. Physicians at the time didn't understand the germ theory of disease. Sexual ignorance was rampant, and physicians believed that masturbation, besides being a moral issue, caused a myriad of health problems, and that circumcision of boys would allegedly cure or prevent the vice by removing the pleasurable gliding mechanism of the foreskin. With the increase in hospital births over home births, circumcision became a widespread social custom by the mid-20th century, with the national rate exceeding 90% in some areas. It's believed that today's rate is less than 50% nationally, with regional variations, notably Western states with the lowest rates of 30% or less. When the American Academy of Pediatrics, or AAP, first began issuing circumcision policy statements in the early 1970s, they rightly determined that there was no valid medical indication for routine circumcision of newborns. Perhaps as a result of the first circumcision lawsuit in 1985, which questioned a parent's right to consent to medical unnecessary circumcision of their child, the AAP began to cite research that recycled previously dismissed excuses for circumcision, like urinary tract infections, penile and cervical cancer, and sexually transmitted diseases, including HIV. Sadly, the AAP focused narrowly on scientific studies, but completely ignored important issues of foreskin anatomy and physiology, medical ethics, consent, and the rights of the child to bodily integrity. The latest AAP circumcision policy statement was issued in 2012. That policy was allowed to automatically expire in 2017 without being renewed or reaffirmed. In October 2025, two former members of the 2012 Circumcision Task Force were interviewed in the Journal of Medical Ethics, in which they walked back their endorsement of the 2012 statement. We'll discuss those specific statements later in our interviews. Meanwhile, medical associations in developed nations with national not-for-profit healthcare discourage or outright condemn newborn circumcision. Clearly, the American medical community stands alone in promoting newborn circumcision. As one researcher correctly summarized, financial incentives for both traditional practitioners and the formal healthcare industry create a powerful system of perpetuation that operates independently of the child's welfare. When physicians and hospitals profit from a medically unnecessary procedure, the ethical maximum to do no harm is compromised, and the child's body becomes a site of commerce rather than a subject of rights. Implicit biases exist in the medical and legal communities that tolerate this radical surgery for alleged benefits that can be achieved through less radical, non-surgical alternatives. Here's a quick review. The female and male foreskin is not extra, redundant, or vestigial. It has been present in primates for at least 65 million years and is likely to be over 100 million years old. Claims by some circumcision advocates that circumcision causes no loss of sensitivity is at odds with the historical roots of circumcision, in which circumcision was specifically intended to desensitize the penis. Even today, urologists use circumcision to desensitize the penis in order to cure premature ejaculation. Phimosis describes a foreskin that cannot be retracted. This is a normal condition at birth, where the foreskin is tightly adhered to the penile head to protect it from urine, feces, abrasive diapers, and so forth. The two structures slowly separate over many years, often not completely separating until after puberty. True phimosis cannot be diagnosed until post-puberty, when the penis has finished its development. As mentioned earlier, forced foreskin retraction prior to this time is never advised. Hygiene and disease prevention are common arguments used by circumcision advocates. Let's review some of these. Genital hygiene for the intact male is extremely easy. Just as we teach our daughters, simply use warm water and, if tolerated, a pH-balanced soap. Condoms offer a higher degree of protection from sexually transmitted infections than circumcision. Pre-exposure prophylaxis medications like PrEP reduce the risk of HIV infection by 99%. These are widely available in developed Western nations like the U.S. Penile and cervical cancer caused by the human papillomavirus, or HPV, can be prevented in both boys and girls by vaccination with Gardasil. All of these non-surgical alternatives have higher efficacy rates than circumcision, making circumcision an anachronistic, radical, and obsolete approach to health and hygiene. There's a prevailing societal, medical, and legal bias that views circumcision as being harmless. This false belief perpetuates the practice. Beyond immediate surgical risks, there are inherent disadvantages of circumcision. Keratinization occurs when the normally protected mucosal surface of the glands is exposed to the drying effects of air and abrasiveness of clothing. The body defends itself by developing extra layers of tissue. On other parts of the body, we call this a callus. Newborn circumcision begins the lifelong process of penile keratinization that results in decreased gland sensitivity. Another disadvantage is the loss of the highly nerve-laden and pleasurable gliding mechanism during manipulation of the foreskin. There are other adverse effects, including unsightly scarring, tight, painful erections, dramatic pigmentation variations, skin bridges, and meatal stenosis, a narrowing of the urinary opening that can restrict urine flow. Circumcised men increasingly report, and researchers are documenting, long-term harms from being subjected to childhood circumcision. These harms can include, either alone or in combination, physical harm, sexual harm, emotional or psychological harm, harm to self-esteem, and harm to family and interpersonal relationships. The disadvantages and long-term harms are so common that hundreds of thousands, if not millions, of circumcision sufferers in the U.S. and around the world are engaged in time-consuming and tedious non-surgical foreskin restoration methods to repair their circumcision damage. GALDEF has made much of this emerging research easily accessible in the attorney resources page of our website and the supplemental self-study guide that accompanies the attorney video. Having established this background information, let's begin interviewing our attorneys. David Llewellyn is a trial attorney and civil mediator in Atlanta, Georgia. His practice emphasizes cases involving medical malpractice, particularly in the areas of genital injury, circumcision damage, and wrongful circumcision. Eric Clopper founded Clopper Law in Los Angeles, California, and is a leading advocate for the child's right to be free from medically unnecessary genital cutting. Can you please briefly list for us in sort of a bullet point fashion the various causes of action that can be undertaken on behalf of an affected person or by the affected person's parents or guardians?
First, the one that immediately comes to mind are those who have been the victims of a negligently performed circumcision, or what we call a botched circumcision. That would generally be a case for medical malpractice. You also have, of course, cases where the circumcision was performed without consent. It is also a battery if you have what's called an unconsented touching, which certainly surgery without consent is. And that gives rise to a cause of action for medical malpractice because it is negligent to do that. It gives rise often to a claim for nursing malpractice because the nurse should have known and informed the doctor not to do the circumcision. Not only that, unnecessary surgery in and of itself is a battery. under most state laws, and this has been true for a long time. And of course, it gives rise to punitive damages also in many states to punish or deter people from an intentional tort, which battery is, because you intend to do something to another. That doesn't mean you may even do it with good intentions, but if it's without permission, then it is an intentional thing because you intended to do the act. You don't necessarily have to have a feeling of animus to the person or bad feeling toward the person or want to punish the person. It's just that you didn't have permission. You can be the victim of a fraud in a couple of ways. One is if a circumcision has been botched and the doctor knows it and doesn't say anything to the parents, and it is later discovered that it is botched, the doctor has a fiduciary duty to tell the parents that he has made a mistake. And if he fails to do that and it's only later discovered, this is most often when the statute of limitations is passed, that fraud tolls the statute of limitations and allows you to bring a case. You can also, of course, have a case for actual fraud when a doctor claims certain things are good when they are not. In other words, if he makes misstatements knowing that they are false about the benefits of circumcision in order to induce you to agree to it, and you later find out that he knew that those facts were false and you relied upon them and agreed to it, then you could have a cause of action for fraud.
There's many different types of causes of action you can bring, and most causes of action, you typically just get money damages. That's how the law compensates you for an injury, right? But you can also bring what's called impact litigation, which changes the law. I prefer impact litigation in this particular realm because we want to protect kids from this. But you can also bring personal injury torts, right? So that might be, a breach of fiduciary duty, because that could be one particular cause of action. You could allege a battery. You could allege constructive fraud, right? Which would also be personal injury and impact litigation. So there's a variety of causes of action you could bring if you had your genitals cut without medical need, either on behalf of yourself or as a guardian, legal guardian. And it kind of depends what it is you're trying to achieve.
I want to touch for a moment on class action. In the 1990s, the National Organization to Halt the Abuse and Routine Mutilation of Males estimated that from 1940 to 1990, in the U.S. alone, more than 66 million unnecessary male circumcisions were performed, and that if only 2 to 10% of those surgeries resulted in long-term harms, there are between 1.5 million and 6.5 million affected persons. With so many affected individuals, under what circumstances would a class action suit be appropriate?
I think you could have a class action if you could show you would have to have one defendant or two defendants. For example, a medical group that was performing circumcisions, a hospital that allows them, and then you could bring a cause of action, a class action, for all those who were circumcised by that group or as a result of that hospital. Say there was a class action suit brought on the grounds that parents cannot consent to circumcision because circumcision is unnecessary surgery and therefore it is a battery, but a parent can't consent willy-nilly to cosmetic surgery on a child. Whether or not that would be successful is another question because circumcision is still so common in the United States. My feeling is that probably initially you're not going to be successful, but it would depend upon the state. As in certain states where the rate of circumcision is quite low, as it decreases even more, and we know it's decreasing from a recent study that shows that supposedly the circumcision rate is now below 50%. As we get lower, I think the chances of a class action like that succeeding are greater. But those are the circumstances in which I can envision it. And even then, you're going to have to prove probably individual harm. But of course, because circumcision itself does cause harm, because it's the removal of normal functioning tissue, I would think that each member of the class would at least have a claim, an equal claim, just for the removal of normal tissue, that is the foreskin.
Female and male genital cutting customs, sometimes called genital mutilation, or FGM and MGM, share a lot of common ground, such as the same anatomical tissue is excised, meaning the prepuce, the foreskin. Both are non-therapeutic. There's no medical need for them. Both are done for social conformity or family tradition. Parents claim it's in their child's best interests, and it's allegedly important for hygiene and health. However, current genital mutilation laws are based solely on gender rather than actual harm. Most offenses against the person under state statutes, based on my understanding, are gender neutral or they're gender inclusive, and they protect everyone, regardless of sex. So situations like laws against rape, females and males can be raped, against sexual abuse, child abuse, domestic violence, these types of things. All of these statutes are gender neutral. Maybe it's the obvious question, but in a specific anti-FGM statute, where is the bias there?
Well, it's in the name and the substance. It says only female genital cutting is prohibited in the name. And then if you read the actual text of the statute, and there's 41 different, or 42 if you include the federal, different anti-FGM statutes as of the date of this filming, some of them expressly prohibit cutting of the labia or the clitoris or the clitoral hood or whatever. And so both in the name of the statute and the substance of the statute, it discriminates on the basis of sex because only those female minors are protected.
This raises the issue of de minimis harm. Explain what that is, and how would you convince a court that non-therapeutic, non-consensual penile circumcision causes harm that is more than de minimis?
Well, I think what you have to do whenever you're trying to convince a court or a jury about the damage caused by circumcision is you have to, one, be able to explain to them through expert witnesses. The lawyer can't do it himself. He has to hire an expert, and there are those out there who know the facts. Many doctors don't, but there are doctors out there who know the facts, to explain the way the foreskin develops in both males and females. Then you have to go into the function of the foreskin, its development over time, because it's not retractable in most boys when they're born. It takes into puberty for the majority of boys to be fully retractable. And then you have to explain the detailed anatomy, the fact that that the foreskin contains most of the fine touch nerve receptors in the penis, that the loss of it changes the mechanics of sexual intercourse, that the loss of it affects the female in various ways. And you have to explain all of those things to show that basically they're the same. And in fact, the male circumcision is more damaging than the most common form of female circumcision, which is merely removal of the clitoral prepuce, clitoral foreskin. People don't realize that. People think that the extreme removal of the inner labia and the sewing up of the outer labia is what is meant by female circumcision. That is the most extreme type, done only in a few places on the continent of Africa. The most common type of female genital mutilation is the removal of the clitoral prepuce. And it's interesting that a federal law supposedly protects girls from that, but does not protect boys from that. And I think that is clearly wrong, that both sexes should be protected from the removal of normal, natural tissue.
On that note, in 2018, there was a case, the United States versus Nagarwala, which involved a Muslim doctor in Michigan who was the first person to be charged under the federal anti-FGM statute when it was alleged she performed minor nicking of the vulvas of her child patients in her close-knit Dawoodi Bohra community. The law was found to be unconstitutional on Federalist grounds because FGM is already technically assault under most state laws. In response, Congress amended the law in 2020 by adding an interstate commerce clause that brought it back under federal jurisdiction. However, when striking down the original law, Judge Bernard Friedman also stated, quote, as laudable as the prohibition of a particular type of abuse of girls may be, it does not logically further the goal of protecting children on a non-discriminatory basis.
I think the judge is absolutely correct. Both boys and girls should be protected, not just one or the other. But it is a more difficult argument to make that the state must protect both if they're going to protect one.
In 2022, I had the pleasure of communicating with Harvard constitutional law professor Lawrence Tribe about existing anti-FGM statutes, particularly the federal statute that was adopted in 1996. Like many legal scholars, Tribe believes a sex-specific law in this case is discriminatory and legally unsustainable. To test the constitutionality of such gender-specific laws, he suggested a strategy that starts with challenging state anti-FGM laws. And I believe that's exactly what you're doing in the case with Hadachek v. Oregon. Can you tell me a little bit more about that case, who the plaintiffs are, and what your goal is with the constitutional challenge?
Well, if we're trying to protect intact children, children who had not been circumcised, how do we file a lawsuit to stop that, right? Because the straightforward way, I'm not saying it's easy, but how our government typically is contemplated is the legislature acts and says no genital cutting unless there's medical need, which is already done for female minors, right? And so one particular way that you could try to protect intact minors is what my law firm is doing right now in Oregon with the funding of Intact Global and GALDEF, so thank you, is you allege on behalf of the intact minors that the laws that only protect female minors from genital cutting actually violate the state constitution's guarantee of equal protection on the basis of sex. So you, depending on what the state statutory scheme is, you can allege a violation of equal protection under the Constitution, and the court, depending on the state, may have the authority to actually extend the anti-female genital cutting laws to all children independent of sex. If you argue that the federal law, the federal anti-genital mutilation law enacted in 1996, violates the federal Constitution guarantee of equal protection, the 14th Amendment, that's a much harder hill to climb because federal courts tend to be more conservative, and you're changing this entire tanker at once, the U.S. Whereas if you win state by state, you're much more likely to have concrete victories, and then the federal government is more likely to support it once a bunch of states change course, which is what we saw in same-sex marriage. And so in Hadachek v. Oregon, we have 7 plaintiffs who are alleging that they've been harmed from medically unnecessary genital cutting of male minors in various ways. So the state of Oregon, represented by its Department of Justice, filed a motion of dismiss, arguing that the plaintiffs didn't have standing. And the state court, after reasoned analysis and a lot of briefing and a 60 to 90 minute hearing, essentially said, I hear and understand your arguments, and who has standing is anyone who was circumcised after Oregon passed its anti-FGM statute in 1999, right? So we have 2 young men who are 26 years old or younger who have had their genitals harmed because Oregon passed a law that only protect females from a similar type of harm, which is great. Now, there were also, coming back to your original question, 2 minors in that litigation who were plaintiffs, who were intact. So they haven't suffered the physical harm of genital cutting, male genital cutting, but they are being deprived the benefit of equal protection of the law because the anti-FGM statute expressly excludes them. So we believe the trial court got it right in terms of finding standing for the 2 individuals who had their genitals cut after 1999, but we believe the trial court erred in finding that the 2 intact minors did not have standing. Now, that case is still at the trial court, so that's something we'll argue on appeal if it goes there, but the ultimate outcome of that is the lawsuit's moving forward in Hadachek v. Oregon.
Okay, so it sounds to me like you want the law to be declared unconstitutional, but not necessarily struck down. You want to see it expanded. Have the court order, perhaps the legislature, to revisit the law and expand it and make it more inclusive so that all children are protected. Is that?
That would be the ideal outcome. And equal protection lawsuits, allegations that one particular statute violates a guarantee of equal protection on the basis of some protected class. There's a lot of jurisprudence around that. But the most concise statement, I think, of what a potential outcome would be in an equal protection lawsuit comes from 1984 in Heckler v. Matthews in the U.S. Supreme Court, where the Supreme Court stated if the right of equal protection is invoked, the courts can either remove the protections from the favored class or extend the protections to the excluded class. So in other words, in this particular context, you can either protect all children or no children, right? But I think that certainly my generation and younger would be willing to accept that we should protect every child equally from genital cutting. And it's my generation who's having kids, so I think we're well positioned to advance this human rights issue.
Is there any advice you'd give to people who are interested in advancing this type of litigation?
Well, if you're a plaintiff, my recommendation is to find an attorney, right? Because if you're filing by yourself, pro se, as they call it, there's just too much procedural jargon and paperwork to really have a real chance of success, especially if you're trying to change the law. If you're an attorney, well, you should come talk with me because I will point you in the right direction. But you need to find your plaintiffs, and you want to find as many plaintiffs as you can, right? Because like with the Oregon lawsuit, we had 7. The court found that 2 had standing, right? Doesn't matter. You only need 1 to have a successful lawsuit. But you want to team up with other people who are trying to accomplish the same thing that you're trying to do. A lot of the constitutional principles, they're not difficult to grasp. You don't need to be a lawyer. We want to equally protect everyone. We don't want to discriminate on race or sex or sexual orientation or you name it. So I honestly don't think it's that difficult to do, but it's difficult to do right. And to do it right, you want to have a lot of attorneys who can kind of give you gut checks and do research and help you prepare. Because although we're prevailing right now in Hatterchick v. Oregon, there's probably 10 attorneys involved in it, right?
You mentioned consumer fraud as a possible cause of action. Generally speaking, what is the statute of limitations pertaining to fraud?
There is no federal common law of torts. Generally, fraud tolls the statute of limitations until discovery of the fraud.
So fraud is making a false statement to somebody. They intend to rely, you intend for that person to rely on it to their detriment, right? And it enriches you typically. I think there's different types of fraud you can allege, right? I think constructive fraud would be the most promising to bring against a medical establishment or a doctor or a hospital. And constructive fraud requires what's called a fiduciary relationship, which is the highest duty that one individual has to another. You know, they have to prioritize their patient's interests irrespective of their own, right? And in this particular surgery that's medically unnecessary, it constitutes a harm. It amputates functional tissue that we know for a fact that that person would want to have, you know, with a 99% confidence margin, and it enriches the doctor. I think you can make a compelling argument that it breaches the fiduciary duty. And so if there's a fiduciary duty, then the onus is on the doctor, if you allege constructive fraud, to prove that that medical procedure was necessary. Now, we know, and it seems self-evident, that circumcision is unnecessary by definition, since the vast majority of men who've ever lived were not circumcised. These are various legal theories that could be advanced against the medical establishment, and I'm open to doing it. Now, the problem with that, there's an increased cost, because if you're going to sue a medical establishment, they're going to hire large law firms, and they're going to make it as expensive and difficult as possible to sue. And I could probably sue 5 states for the cost of suing 1 hospital, right? And the state of Oregon, for example, they're not it's not a zero-sum game. If they lose, it's not like they personally lose any money or they lose their jobs or whatever.
On a related note, in 1989, the American Academy of Pediatrics, or AAP, released a policy statement basically promoting the alleged benefits of circumcision. In 2021, the Llewellyn family, whose son was circumcised based on the 1989 recommendation and who suffers long-term adverse consequences from his circumcision, claimed that the AAP acted fraudulently in promoting the alleged health benefits. The judge determined that the AAP cannot be held liable for its statements. So with that, who can be held liable under fraud statutes, if at all, for soliciting and performing medically unnecessary surgery on infants?
Well, I was involved in the Llewellyn case, and I will say, with all due respect, I disagree with the court. We argued, one of the arguments in that case was that the American Academy of Pediatrics was liable under what's called trade association liability. And the court felt, as I recall, that they really didn't control the marketplace. I'd be willing to bring that case in another state because I think the AAP does indeed control the market. I think that people look to them for authoritative guidance, just like they look to the CDC. And in my opinion, the 2012 statement, as well as the 1989 statement, failed to reveal facts necessary to be full and complete. None of the AAP statements from 1989 on have actually dealt with the structure of the foreskin, its sexual importance, its anatomy, and the like. It's just ignored. One of the statements says studies suggest that there are specialized nerve endings. Well, the study that it's talking about doesn't suggest anything. It proves it. And in fact, there's an article that just came out within the last month or two that reiterates the fact that there are specialized nerve endings in the foreskin. So the fact that the AAP or the members of the committees knew the facts and had them presented to them and then did not present them to the public, I think does, in my personal opinion, make the AAP liable for fraud. Whether or not a court's going to accept that any place, I don't know. But I think that a trade organization that puts out facts to encourage an unnecessary surgery without stating all of the facts necessary for a reasonable decision is liable for fraud.
So would you say that reliance on an AAP policy statement is a sufficient defense by a hospital, a clinic, or a physician for performing newborn circumcision, or not?
Classical fraud is a misstatement known to be false, a statement made by a person or an organization that's known by that person or organization to be false, to induce reliance by another upon which another relies to its detriment. So to the extent that they know these things and don't reveal them, and a parent decides, well, I'll just have this circumcision done, and then later finds out the facts and said, well, if I had been told all of these facts, I would never have consented to this, then I think that is a good cause of action for fraud. Now, can a hospital rely upon a fraudulent statement by somebody else as a defense? That's interesting. I would maintain, if I were representing the plaintiff, that they couldn't if they knew the facts, or if they recklessly ignored the facts, because after all, the facts are actually out there in the medical literature. In fact, I know that many people submitted all of these facts to the AAP before they made their 2012 decision, including me.
In October 2025, the Journal of Medical Ethics published an article by Max Buckler, who interviewed two former members of the AAP's 2012 Circumcision Task Force, who co-authored that policy, which automatically expired in 2017 without being renewed or reaffirmed. In Buckler's article, those task force members essentially walked back the task force's conclusion that, quote, benefits outweigh risks, end quote. One physician stated, quote, when you look at all the data, I don't think you can honestly say in a recommendation that the benefits outweigh the risks, end quote. The other physician said, quote, it is a non-therapeutic procedure. If it can be called a preventive medicine, it is at the very weakest level. There is nothing wrong with the uncircumcised penis. You cannot recommend circumcision based on the medical benefit alone, end quote. And he further added, quote, it's not really a medical practice. It's only a, quote, unquote, medical procedure in the sense that medical professionals are performing it. What are your thoughts about the utility of using those statements in a court of law, attorneys using those statements? Would they be beneficial?
Perhaps. I mean, it depends what the disputed issue of fact is in the case, right? Like in my current constitutional litigation with Oregon, it appears that the state of Oregon is not going to contest that circumcision is harmful. And every secular medical organization in the world advises against it, right? Some in very strong language. And the American Academy of Pediatrics in the United States, old position in 2012 was the benefits outweigh the risks insofar as you should reimburse it for medical insurance reasons. Because this is a billion-dollar industry, you know, cutting off the functional tissue of children and then selling it to biomedical and cosmetic companies. So we're talking thousands of millions of dollars are involved in cutting off the genitals of our children in this country. So in terms of certain authors of the American Academy of Pediatrics saying, you know, it actually isn't a medical procedure, it's not therapeutic, I think that's helpful. I think that it's telling that we're winning the battle for children's rights, that they're walking it back.
Well, I think they're very useful because it basically shows that the AAP statement in 2012 was fraudulent. We know that a member of that committee testified a few years later that when asked, well, nobody knows the function of the foreskin. Okay, well, this is ridiculous. Okay, people did know. I personally sent information about the function of the foreskin to one of the lawyers for the AAP. They have plenty of information, and for them to try and essentially defend a cultural practice by saying the benefits outweigh the risks is, I think, just plain dishonest. Is that simple? And do I think that that lays the possible foundation for a lawsuit against them? Yes, I do.
Many people believe that newborn circumcision falls within the domain of quote-unquote parental rights. Are there limits to such so-called rights?
Well, of course. I mean, actually, the question should not be parental rights, but parental duties. Unfortunately, because of the way our law, which arose out of the Middle Ages and what's called the common law that's developed over a long period of time, there's this idea that parents can do what they want with their child. Well, we know this is not true. In the medical context, parents really don't have a right to consent to circumcision just because they want their kid to look like dad or to look like themselves or to look like somebody else, or because they prefer the circumcised penis over the intact penis. They don't have a right to do this. Someone on behalf of a child is willing to make the argument that parents can't consent and succeed. I would love it.
Well, as a society, we agree that parents have rights to their children, but we also agree that those rights are limited. In Oregon, for example, and I know this because we're suing them right now, you can't pierce your child's foreskin, right? That would be against their regulatory code, right? No genital piercings for minors. But you could take the entire foreskin, crush and amputate it, and permanently maim the child for life, right? And so those laws contradict, and the law sometimes doesn't make sense. And when it doesn't, that's telling you that there's something that needs to be fixed. So we all agree that parental rights have limits. It's just we disagree where those limits are. Now, a lot of people believe that parents have the right to cut off large parts of their children's genitals because it's always been that way. But that's a terrible argument. You know, I like the saying that tradition is peer pressure from dead people, right? And we need to ask the more enlightened question, what's in the best interests of the child? And that is to protect their bodily integrity and not inflict incredible trauma and lifelong loss of sexual function and bodily integrity. So I think my generation is really receptive to that argument, and it will prevail. It just needs a little push.
I want to jump back in history here a little bit. The very first circumcision case in the U.S. occurred in 1985 in California, in Marin County Superior Court, when Trudy London, who circumcised her son Adam, and then later learned it was not medically necessary and indeed harmful, brought a case. She hired attorney Richard Morris to raise the core question of whether parents could legally consent to medically unnecessary surgery on their child. Without thorough consideration, Judge Warren McGuire dismissed the case within about a month, saying parents do indeed have such a right. Do you think society has changed enough since 1985 to warrant bringing such a case again?
Usually the law follows society, and until it becomes recognized in general that circumcision is wrong to do to a child, at least if it's a medicalized circumcision. Until you get to that point, I don't think that you're going to be successful with such an argument. That's not to say that such an argument is not valid.
You talked about the younger generation today feeling differently about circumcision. Do you think society has changed enough to warrant bringing such a case again to ask that central core question about whether parents can consent to medically unnecessary surgery on their children?
Generally speaking, let's take same-sex marriage, constitutional right across the board in the U.S. When that same issue was first introduced to the U.S. Supreme Court in the 70s or 80s, the Supreme Court justices said, we don't even need to issue an opinion because it's not a substantial question of law. It was just dismissed outright. It seems like the judge in the 80s decided, hey, I don't even have to take this seriously, right? And that's happened with any human rights movement, is that it's been met with just dismissal early on. So I think it had more to do with the culture and the judge's own ignorance than anything else.
I've heard, as I'm sure you have, time and time again, young men who want to sue their parents for consenting to the circumcision. Now, I can imagine, no parent has a crystal ball that can tell them how their son will ultimately feel about this permanent genital modification. Yet, these are the people who, quote, carry the legal responsibility because they sign a consent form that the hospitals and the physicians and the nurses keep soliciting them for. That's a problem in itself, in my opinion. But if there were a case where perhaps a young man, maybe he already has a contentious relationship with his parents and he has no real relationship to lose, or there might be a young man who has regret parents who sincerely regret that they made the wrong decision because they were coerced or solicited for this. And those parents might be willing to cooperate with their son suing them. Do you think either of those scenarios could maybe create some impact litigation?
I think as a practical matter, juries aren't going to pound parents who relied upon doctors saying this was good. They just aren't going to do that. Might such a case raise awareness to the fact that this is wrong, that parents don't have a right to consent, even though they may have signed a form, because the general principle is that parents can only consent to necessary surgery on their children, not to unnecessary surgery. I mean, the AAP, interestingly enough, one of the committees of the American Academy of Pediatrics, as I recall, has actually stated that proxy consent can only occur, and that means consent by somebody else for somebody else. But in the case of a child, can only occur when surgery is necessary. And since circumcision is not necessary, parents really have no right to consent to it by the AAP's own terms. So yes, I think it would have some impact if it got any press. And that is another problem, that often the press ignores cases that they ought to publicize, which is a real problem when it comes to any sort of impact litigation.
Well, it's an interesting question, and I've had prospective clients that fall into both of those categories. I don't think that I would probably take such a case just because I don't want parents to think that they're going to get sued. Parents are also the victims because they've been deceived from the medical industry, pushing a procedure that's not only elective but actively harmful, right? And it benefits them because they make $1 billion plus a year from it. But parents do have duties to their parents have duties to their children that cannot be waived.
Mm-hmm. So that creates kind of a catch-22 situation in which you have hospitals openly soliciting this surgery, marketing this surgery to parents, and yet they require the parents to authorize and consent to the surgery through signature on supposedly a consent form, which presumably absolves the hospital or the physician of any responsibility, but yet parents cannot be held responsible for this.
Well, hospitals can't absolve themselves from liability by saying, hey, we had the parent sign for it. The doctor is the fiduciary to the patient and the patient's parents, right? But the doctor has an independent duty to issue his or her own medical opinion based off of the patient's needs, right? And so if the doctor is advising a medically unnecessary surgery that harms the infant and enriches him or herself, that's a breach of that fiduciary duty. So I don't think there's any consent form that would absolve the doctor of that breach of fiduciary duty, because the law doesn't assume the parent has any specialized medical knowledge, and in fact, the vast majority of parents do not.
You talked about parents not being able to consent to, ethically, they can't consent to medically unnecessary surgery.
Correct.
In 2006, a California appeals court issued a verdict that did not involve circumcision itself, but was related to some other medically unnecessary surgery. And that case was Tortorella v. Castro. And they concluded, quote, even if a surgery is executed flawlessly, if the surgery were unnecessary, the surgery in and of itself constitutes harm, end quote. Do you think this verdict can or should be applied to non-therapeutic infant circumcision?
Of course. They're absolutely correct. And in fact, I think that was my point, that unnecessary surgery is a battery, period. That's essentially what that's saying, except because removal of normal body tissue is a harm. It is not good. And in fact, the statements by the doctors that were quoted by Max Buckler in his article just add to that. I mean, yes, I think that it is harm in and of itself, even if a circumcision medically is done perfectly, it is still wrong.
I think that it can and it should be used in any case that's arguing one of the previous theories we talked about, because every circumcision constitutes every circumcision does constitute a harm, but more broadly speaking, every surgery constitutes a harm. When you take a scalpel to a body and start cutting it open, that is harmful. But the reason surgery is legal is because the benefit outweighs that harm, right? In circumcision, the amount of times the benefit outweighs the harm is vanishingly small, right?
Circumcision, altering the genitals of an unconsenting child, even if they are your own child, raises the question of religious freedom. What are the limits, if any, to religious freedom?
Well, I think it's Prince, Massachusetts says you can't harm, you can regulate things that would harm a child. Okay. I think that given the importance of circumcision to at least two religions, and given our First Amendment, and given the makeup of the legal profession as well as the medical profession, it will be a long time, if ever, that we will outlaw male circumcision done religiously. I think the best we can hope for is for parents of those faiths to reconsider whether or not this is really necessary within their religious context. And we already know from the organization Bruchim in the Jewish community that is occurring. The questioning of circumcision is occurring within that community. There is some questioning within Islam, perhaps less, but I know that at least one Egyptian physician who has seen many problems with circumcision in his country thinks that it is not required because it's not in the Quran. And even though he is a religious Muslim, he thinks that they should stop doing it. I think the way to change the religious community is to first of all change the community that's doing it for non-religious reasons. And if you change that, then I think argument is the best way to change it. Now, I do think that it is possible that you can prohibit it from being done by physicians for so-called medical reasons. That I think is possible, and I think may come eventually. You may even get medical organizations to condemn it.
Well, just like parental rights, we all agree that we have religious freedom. But it's like, what are the boundaries? What's the contours of that, right? And as a society in the U.S., we've agreed we don't care what your religion is. You will not be circumcising your female daughter because it is in her interest to keep her bodily integrity and not undergo this harmful procedure. And if you believe your God requires it, well, that's too bad. But just like with parental rights, people believe that it's within their religious freedom to be able to cut off part of their children's penis because they were taught that as a child, or their religion requires it, or whatever. But there's also an entire body of law as to where is the line with religious freedom, right? And legislatures, either state or federal, could make an exception for male genital cutting, or they could just say, we're going to apply the same law to everyone neutrally. We're not going to target any religion. So if, for example, a state were to outlaw genital cutting without medical need, right, on a sex-neutral basis, as long as it's not targeting a religion, as long as it has a rational basis, it could survive. And you could also argue that if a child's circumcised for their parents' religion, that actually violates that individual's religious freedom. Because what if he doesn't identify with a religion that cuts off large portions of children's genitals, right? So, the religious freedom could go both ways.
Many physicians and health professionals fail to update their medical education with newer information about the beneficial functions of the foreskin, the natural development of the child's foreskin, or the long-term harms of circumcision. Others were previously trained to forcibly retract the child's foreskin, which is now strongly discouraged. How does this medical ignorance harm the child, and does this qualify as personal injury, and would failure to know this information constitute malpractice?
Well, there's several parts to it. Yes, doctors do not keep up. The development, they ought to. The question of forced retraction has been an issue for a long time. So this is known, and it is now well publicized that it is wrong to forcibly retract the foreskin. And so, yes, I think that's absolutely a case. And they are winnable because you can show that that's just absolutely wrong. And in fact, I would encourage any parent whose child has been forcibly retracted to try and find a local lawyer.
Research has shown that while some circumcision sufferers are aware of their harm in early childhood, most don't fully realize their circumcision harm until well into adulthood. Because of their unique vulnerability as newborns, do you think circumcision sufferers deserve to have the limitation period expanded to a later age, let's say age 25 or later?
Well, you're asking me to be a legislator now and not a lawyer. I mean, look, how do laws get passed? You have to have individual legislators who are interested in the topic. And then when they introduce a bill, the lobbyists show up. And trust me, hospitals and doctors their lobbyists have more money than trial lawyers or individuals. And so I think the chances of getting anything extended that far are really out of the question. I think it's just not going to happen. That's not to say that I don't sympathize and empathize with those who discover harm much later on.
Typically, the statute of limitations is told to put on pause until that person's 18, right? But still, a lot of people have no idea what's going on sexually with their body, whether or not a big part of their penis was cut off at birth, even when they're 18. It's called the discovery rule. So your statute of limitations for various claims typically does not begin to run until you discover the harm.
Under what situations would discovery of circumcision harm apply, and what would that mean?
If a physician knew that they did something wrong and didn't tell the parents or didn't tell the patient, let's be broad, that failure to tell the patient tolls the statute of limitations because there's a fiduciary duty by the physician to the patient to tell them. So that when the patient discovers that something was done wrong, the statute's been told up to the time of discovery, then the statute of limitations begins to run. Okay? The problem in regard to circumcision is you knew you didn't have a foreskin all these years. The court probably will not accept this as discovery. The doctor didn't conceal from you the fact that you were circumcised. Your parents didn't tell you what it was, which unfortunately is very, very common. So there's a great deal of misunderstanding in this regard. My view always has been that kids ought to be told the truth. Okay? We owe it to our children to tell them the truth.
Impact litigation is any legal case with the potential to change the legal landscape or to set new legal precedents or legal standards. Which causes of action that we've discussed so far stand out to you as having the best chance for becoming impact litigation to benefit the most number of individuals going forward?
I suppose that the one that would perhaps have the most impact would be a class action against a hospital or a medical practice just for doing circumcisions, knowing that they are unnecessary. And I think that's maybe where, just speculating now, the Buckler article is most useful, because once that's been published in a major journal, as I recall, and once that has been percolating long enough where doctors ought to know it, then I think perhaps in a year or two a class action, even by parents who had agreed to circumcision of their child, they bring it on behalf of the child, that such a class action might be successful and might have significant impact.
Well, what I believe would be most helpful is the one that I'm doing right now. I'm representing the two remaining plaintiffs in the Hadajek v. State of Oregon, and that's arguing that laws that only protect one class of children from genital cutting, female children, violate the state constitution's guarantee of equal protection, right? And so I think that has the greatest benefit of helping the most children in the shortest amount of time. And it's also a defendant who may be willing to work with us, a state. Because if we start suing a hospital or a doctor, which I'm also open to doing, let's say with constructive fraud, that could also be very helpful and help a lot of children and impact the law, right? If we get a verdict that's upheld on appeal that it is constructive fraud to perform this medically unnecessary surgery on a child, right? Then every other doctor may hear, hey, you could get sued for constructive fraud, and that could stop circumcision immediately. So could a judicial declaration that says every child needs to be equally protected. Or so could a judicial declaration that says, you know what, the anti-FGM law violates equal protection guarantee, so I'm going to strike the statute, and this order goes into effect 6 months after the legislature meets, which means the legislature has to go in and fix that statute and make it constitutional, which is really easy if you protect every child equally from genital cutting, right? Now, you can have religious interests and all that, and you could make an exclusion, you could make no exclusion. There's a whole body of law on how religion and law intersect.
Let's talk a little bit about the types of persons who would make ideal plaintiffs in filing impact litigation. Perhaps the largest class of plaintiffs would be those born with typical male genitalia and who identify as male, what some people might call non-intersex cisgender males. But among others that are subjected to newborn penile circumcision are intersex individuals who might have hormonal, chromosomal, or reproductive sex characteristics, but nonetheless have typical male genitalia. There are also transgender females born with typical male genitalia, and the excision of their penile foreskin can adversely impact the outcome of gender-affirming vaginoplasty. Would individuals from these communities also have a role to play in impact litigation to protect children's genital autonomy?
Well, of course. And I know from having heard intersex individuals speak that many, if not most of them, would prefer that nothing were done to them and they just lived as they live as intersex individuals. Certainly, of course, removing the foreskin of an individual who then decides that they are actually, let's say it's an individual born with male genitalia who transitions to female. As an infant, if this was done to an infant, circumcision was done to an infant, you have no idea which way the child's going to go, whether they're going to be cisgender, whether they want to transition to another gender, whether or not they're gay. We just don't know. Do I think all of these individuals have the same rights as any other cisgender male to complain and to bring lawsuits? Yes, I do.
Well, absolutely. So talking about the equal protection theory that we discussed earlier, it's if you're going to protect females from genital cutting, you have to protect all children equally. Well, that all children equally includes males, but also includes intersex, right? Or any infant who may later identify as trans female, right? Because anyone who's born and assigned female at birth, saying, oh, this is female from the hospital, they're protected by the law, and they can't have their genitals cut without an urgent medical need, right? So I think an intersex plaintiff, so someone who is intersex, who's had their genitals modified for cultural reasons or aesthetic reasons, would be an excellent impact plaintiff, because in some parts of the country, male genital cutting is still normalized, but intersex genital cutting is widely regarded as something that we've moved beyond, right? So an intersex plaintiff might even have a higher chance of success as an impact litigant. Ideally, you would have plaintiffs who have been harmed from male genital cutting and intersex genital cutting. And if the person who was harmed by the genital cutting later identifies as trans female, well, they could be a plaintiff as well, right? I don't see anything different with that, except that it may garner more attention just because it's interesting.
I've heard that oftentimes the plaintiffs get dismissed for lack of standing because the court decides, oh, you're already circumcised, there's no redress, there's nothing we can do to help you. What do you think would be an effective response to the court to impress upon them that, yes, these people were harmed and they do have standing because of that harm?
If you want to show the harm, you're going to do it just as though we're doing one of these cases to prevent a child from being circumcised. I mean, what you have to do is you have to show the court that this is harmful and damaging.
So to support a plaintiff's claim of harm in a court of law, what kinds of documentation would you suggest a plaintiff obtain for their case?
So I want to see the first pictures of the child before the circumcision, any picture of the penis before the circumcision. Then, of course, I want to see every picture afterwards. So you want to get the records from the birth, from the circumcision itself. You want to then get all the other medical records up to the time you're bringing the lawsuit.
So in terms of particularly an older adolescent who becomes aware of their harm and they're waiting for age 18 so they can hopefully bring a case, what kind of professionals do you think they should be consulting with in order to help create a file to document their harm that's ready to go when they launch the suit?
I want to emphasize that there are not many states left where a child can bring a malpractice action after the age of 18. There are few. Most of the states have done away with that, probably because of lobbying by the medical profession. If you are in a state where you can bring it after the age of 18 and you discover it, well, you need the same sort of photographs. You need the same sort of, you need all of your medical records from birth on, if they're still available.
We just need your attestation that, hey, I was harmed from my circumcision, and, you know, whatever other information you want to provide me would be enough. Oh, I feel aggrieved. I feel like I'm treated lesser than. I feel like, I have some issues of hypersensitivity or no sensitivity, sexual problems. You can get into the details or not. Now, how much detail or supporting documents we need depends on what the defense does. And so if the defense counsel is not arguing that you were harmed, then they may just accept as fact for the purpose of this lawsuit that you're suffering sexual difficulties, right? But if the defense does not concede that, then you may need to get records from a therapist or a counselor or a urologist, right? Maybe you need medical records. So it really depends what the contested facts are in the litigation. And if you get that ahead of time, well, it can only help.
So would you be suggesting that potential plaintiffs seek out urologist opinion, psychiatrist or psychologist, maybe a sex therapist, that can document from their records that, yes, this potential plaintiff I've been seeing since such and such a date, and this is what I've noted is the presenting and the actual problem that this plaintiff faces?
I think that would be helpful, yeah. I mean, the United States is a genital cutting culture, and so a lot of professionals are raised in genital cutting cultures and have had their own genitals cut. And so although the vast majority of doctors in the world advise against circumcision and do not do it, if your doctor was circumcised and grew up in a circumcising culture, he or she might be supportive of it, right? But a doctor who knows what's going on and how the foreskin works together with the rest of the penis to function, I think would be a good person to talk to actually document the harm. And so you want to collect what evidence might be helpful to prove whatever your claims may be.
If you are really disturbed and upset, then you ought to consult a counselor of some sort, preferably a psychiatrist or psychologist, who could document the psychological harm that you're suffering. You're going to need to differentiate between that harm and any other psychological issues you may have. And you may not want to put your whole psychological history out there, because once you hire a professional to deal with you psychologically, if you're going to use that as evidence, the defense is going to have a right to find out everything else in that file about you psychologically. And you may or may not want that to happen, but you need to know that's a risk. But if a young man was truly distressed, and there are some, I mean, just by we know there was a young man who was English, who came to Canada, had phimosis, inability to retract the foreskin, was only offered the option of circumcision, had a circumcision, and then the way he physically felt was so painful. We don't really know whether or not he took off too much shaft skin or not, the doctor, but I expect that's what happened. He found it very uncomfortable, very painful, and eventually took his own life.
And suicide is not something that's that rare in terms of people who suffer from circumcision. The people in the genital autonomy movement have said repeatedly, and they have lists of names of young men who've taken their lives because of this.
That's one thing that parents need to think about. You never know how a child is going to react to things you agree to be done to them. And it is unfortunate that people say, well, it must have been something else. Not necessarily. There are people who are genuinely distressed and have every right to be. And yes, unfortunately, sometimes that leads to suicides. You know, if your son tells you, I am distressed at being circumcised, take him seriously. Okay, even if you agreed to it, for heaven's sakes, take it seriously and listen to the child, because there's nothing worse. I've heard on the internet where parents have laughed at the child or the young man, and there's nothing more devastating, because indeed they have every right to be upset at having lost something, and they need to be empathized with, not made fun of or belittled.
And of course, it affects their interpersonal relationship with partners, with family members, and so forth. So get as broad documentation as you can about the various ways in which you've been harmed.
Absolutely. I think that's good advice. I also think it's just plain good advice for your own mental health. Okay? I mean, look, bad things happen to everybody in life. And to a certain extent, to the extent you can adjust to it, you need to. And so all the help that you can get is important. The problem of going to a urologist and the like, I'll be honest with you, many urologists do not understand the penile skin adequately. They just don't. And in fact, there's a new study out for Spain, a new anatomical study on a number of cadaver penises that are describing things that have only been hinted at before. We really don't know the full anatomy and function of the human penis yet. And that may be surprising to people, but it's really true. Mm-hmm. What we have discovered over the last 30 or 40 years is how highly innervated, that means filled with nerve endings, the foreskin is, and its important sexual function. Unfortunately, the American medical community has actually, I think, tried to ignore this rather than embrace it.
Thousands of men in the U.S. and around the world are using non-surgical foreskin restoration methods to repair the damage of their unwanted circumcisions. But that's time and labor intensive. The organization ForGen is in clinical trials right now to perfect the use of regenerative medicine to help circumcision sufferers regain their genital integrity. But that, when it becomes available, is a procedure that will likely be very costly. When regenerative medicine for foreskin restoration becomes available, what role do you think that will play, if any, in future impact litigation, particularly with regard to redress of harm?
Well, the reason genital cutting or circumcision survives is mostly ignorance, because we don't talk about it. But any rational analysis of this behavior yields, of course, it's harmful to crush and amputate functional genital tissue from children, right? But because we do it to infants and children at such young ages, they've never lived a life with an intact penis, so they don't know that it's better. It's like, do my eyes function better when I have eyelids? Of course they do. Does my penis function better when I have 15 square inches, the mobile tissue and all the sensory tissue? Of course it does, right? And so if ForGen succeeds and is able to provide some therapeutic remedy, right, able to regenerate that tissue, and it actually works and functions as it should, which is a very high bar, well, then it's going to change the culture radically, because there will be no question. It will be like, of course your eyes function better with eyelids. Of course your penis functions better with the foreskin. In terms of how it would change the legal landscape, I think it would change everything, because there would no longer be any debate. But men and their identity is also tied up with their penis and how it functions and all that stuff. So it's really difficult for men to understand that what happened to them before they can even remember was harmful. It harmed them, as it harmed their body, it harmed their sexuality, you name it. It also it may implicate their ego and their self-image. And so it's a lot easier to believe the cultural lie that this was good for you, right? But if there were medical therapy that was able to restore the penis to its original form and function, there wouldn't be any debate anymore. I'd say, hey, I've had it both ways, and I could tell you it's better to have your entire penis.
What is the cost for that procedure? That is one of the damages that you would be able to get as a circumcised male, assuming that it's brought within the statute of limitations and you can convince the court that somehow you were wronged. I mean, right now, I suppose that if you could bring a suit successfully for having been circumcised as an infant, just a normal, properly performed circumcision, part of the damages would be the cost of the different devices that you have to use and to restore your foreskin. And indeed, you could argue that the time and effort that you have to put into stretching the skin to create a faux foreskin, a false foreskin, would be a damage, and that you would be able to recover damages for having to restore your foreskin.
What advice would you urge attorneys to adopt, and which traps would you advise them to avoid when taking on impact litigation involving male genital cutting?
Well, it depends on the plaintiff and the state and how much money you're willing to spend, right? Because if you're suing a hospital or a doctor or some combination thereof, you need to be prepared for a death match that's going to be very expensive, right? That's just something to be wary of. I think in terms of advice, affirmative advice, be very aware of what you're trying to achieve. What is your desired outcome? What's your desired remedy, right? And is your plaintiff going to present well in court if it goes to trial? It really depends on what the cause of action is, though, and you want to talk with other lawyers, right? Other litigators, preferably in that state, because they're going to know some of the nuances of litigation that you may not be familiar with.
Well, first of all, if you're going to do this litigation, you need to know more than the doctors know. So you need to start studying the anatomy. You need to immerse yourself in that. Then you need to study a little bit about human rights law and the things we've discussed about parental rights and the limitations on parental rights. I mean, that's the first thing, is you need to educate yourself about this deeply, because the doctors are going to go up and they're going to try and fool you. I mean, I've said this before, but in one case where part of the glans penis had been cut off a child, and we were able to show that on a slide, their expert, the defense expert, said, oh, well, that's just the exterior of the foreskin crumpled up. And so I said, well, will you be so kind as to name the layers of tissue in the foreskin? He couldn't do it. And then you also need to immerse yourself in the question of constitutional law, the question of fraud, and all these other things as things come up, and be prepared to take it. Then you have to be prepared, frankly, if you're going to be real brave and bring a novel cause of action, you have to be prepared for the fact that the defense, if it wins, may try and get attorney's fees from you. And so it is useful to have a big bank account or an organization with a bank account that's willing to back you if you should unjustly be hit with attorney's fees.
I believe you told me at one point that attorneys who want to take on these types of cases need to believe in the case, they need to set up the case properly in advance, and they need to have effective cross-examination skills. Do
Correct.
you want to say anything more about those?
I think I've just covered it. I mean, how are you going to cross-examine a doctor if you don't know the anatomy, if you don't understand this, if you don't understand the method of circumcision? There's several main methods of circumcision. You need to immerse yourself in those. I think that we don't have enough lawyers who know this. We don't have enough doctors who know it. So I think everything that I've said about needing to know the anatomy, needing to make sure that you have gotten all the records, that you've got a good client, a client who will appear well before a jury or before the court, is all very important. Having said that, these, certain cases are winnable. Preventing a circumcision, for example, which I have dealt with several times. I've had judges, when we got finished presenting our evidence, going, Why doesn't everybody know this? Why am I even here? Because they're just so amazed that the people who want to do the circumcision have presented doctors who don't know the truth. Okay, we have presented doctors who do know the truth.
I think you need to be very confident and very capable, right? And I'm both, right? I've run into many lawyers and I've been unimpressed by some and very impressed by others, right? And so you really need to believe in the case and what you're doing, and you really need to know what it is you're doing, right? And those things, they may teach you some of it in law school, some of it is from experience, some of it is just, innate ability. But the reality is it's difficult to do. It takes a lot of time and energy, and you need to really be 100% behind it and ready to, do what is necessary to win.
From the plaintiff's perspective, what kind of treatment would you tell potential plaintiffs to expect to receive from opposing counsel?
Chances are you may never even talk to them at all. But your name might come up if people Google you, how to check the organ or whatever is an example.
I haven't had parents really scoffed at, with the exception of a few of the first cases where we had wrongful circumcision cases, where I did in one mediation where the good old boys in a southern state were sort of laughing at this mom and dad until I put up the film showing what was done in a Gomco, this one type of circumcision. And with the screams of the babies, the room became very silent. And the mediator in that case looked and said, well, if I'd known that, I'd have never done my son. And we settled the case, which they were laughing at us beforehand. But I do think you do need to be prepared for being scoffed at and perhaps having somebody be rude to you, and you have to be sort of tough.
If you had to characterize the alleged benefits of circumcision in one or two hard-hitting sentences, what would you say about it?
I'd say the benefits of circumcision are akin to the benefits of cutting off your eyelids, right? None. These are internal structures for a reason. They're very functional, very important, and nobody cuts it off if they have the choice. And by nobody, I mean over 99% of intact individuals. So it's just a cultural norm that was introduced to stop children from masturbating in the US, right? And it was introduced earlier as a tribal mark that you can never abandon, right? It is a horrible thing to do to a person. And just because a billion or multi-billion dollar industry has popped up in the US to profit off of it doesn't mean that it has anything to do with health. It has to do with money and control.
The benefits?
The alleged benefits.
There aren't any. That's simple, I mean, the biggest alleged benefit would be that as an adult, you don't have to retract your foreskin to wash and to rinse. That's crazy. I mean, that's like saying, let's cut off our ears because we don't want to clean out earwax. I mean, that's nuts. So I don't think there are any benefits to circumcision at all. And I think it's unfortunate that, in 1971, the American Academy of Pediatrics, the first statement they issued that I know of was from the Committee on Fetus and the Newborn that said there is no medical reason for circumcision in the neonatal period or for neonatal circumcision. They said something like that. When I saw that as a young man, I thought, well, that's the end of circumcision. I was wrong. It's that deep. That's one thing I've learned doing this work. This is tough because it's hard for somebody to say something was done to me by a doctor who cared about me, my parents who cared about me, that was wrong. And that's just tough. And I think that's the psychological thing that keeps driving circumcision.
Finally, if you could say one thing to attorneys who might want to pursue impact litigation regarding non-therapeutic circumcision and children's rights, what would that be?
Well, get ready for an interesting adventure, I guess I would say. Okay? You can make a difference in the world if you're successful, but you have to be willing to take the economic risk. If you're going to step outside the traditional boundaries of the law and try and advance the law, then you have to be willing to take some sort of risk. So I would suggest that you get an organization like GALDEF behind you, or some other organization that can help you with the fees, or have a client who has enough money who is willing to back you. Because there are folks out there who are angry about circumcision, who do have money and are willing to assume the risk in such a case?
Well, as I said before, you want to talk to other lawyers who know what they're doing and who are supportive. So if you're going to file impact litigation, I'd encourage you to reach out to me at eric@clopper.com or to you, thammond@galdef.org, and get connected with the movement of people and the network of attorneys who are doing this type of work, because we can help each other and you don't want to be doing this alone.
This has been very helpful, very educational and informative. Thank you very much.
Well, thank you, Tim. It's been a pleasure.
Thank you very much, Eric.
Thank you, Tim.
We hope you've learned and benefited from the information contained in this video. In the end, it's important to recognize newborn circumcision for what it is not. Circumcision is not healthcare. It's a social habit that most doctors are too afraid to oppose and other doctors are happy to promote for financial gain. The practice is perpetuated by social, medical, and legal biases that must be identified and eliminated and challenged if impact litigation is to be successful. The first step in impact litigation is for circumcision sufferers to step forward as potential plaintiffs. The GALDEF website was created to educate not only attorneys but potential plaintiffs as well. Please explore the many resources we've made available, including relevant downloadable articles dealing with medicine, ethics, law, and human rights, as well as videos and ebooks. If you found this video helpful, please subscribe to our periodic newsletter. Volunteer your time, talent, and skills to help make GALDEF more effective, and let your friends know about us. GALDEF is an IRS-recognized 501c3 nonprofit organization, so please consider donating as generously as you can. We allocate 80% of your donation to our cases account to fund future impact litigation. With your help, we can change the legal landscape in the U.S. to bring about equal protection for all children.